Hello everyone, and welcome to today's video. In this video, we'll be discussing Jeffrey Zunich, a sovereign citizen I previously covered in a video last Friday. In that video, he refused to appear in court in person despite being ordered to do so by the judge. He claimed that he would not attend because the court would allegedly kidnap him and put him in jail. After reviewing my previous records and court documents, I discovered the reason behind that statement. It turns out that Jeffrey had previously attended a probation revocation hearing that did not end in his favor. Today, we're going to take a closer look at that hearing to understand what happened and to provide the full context behind his comments. With that background in mind, let's get started.
Anybody else that is here on the docket besides Mr. Zunich? Okay. All right. Then the next matter, I think the last matter that we had on the 945 docket is the matter of the People versus Jeffrey Zunich. It's a revocation of probation hearing. Mr. Zunich, are you present?
Yes.
Okay. Why don't you come forward and have a seat at the table?
I have a notice, Your Honor, that I'd like to file with the court
Okay.
for the record.
Okay.
Mr. Bama.
Thank you. I'm going to take just a minute to review that, Mr. Bama, if you would too. All right. Can I have the appearances of the party beginning with the People first?
Matthew Bama, 41464.
Okay. And Mr. Am I saying it correct? Zunich?
Zunich.
Zunich. You're Jeffrey Zunich, correct?
Yes.
Okay. And so we are recording the proceedings. We don't have a court reporter here. So I'm going to ask you some questions, and if you could just make sure you speak into the microphone so that we capture everything that you say. Prior to the start of this matter, Mr. Zunich presented us with a letter, a copy to the People and a copy to myself regarding his grievances about the process which is about to take place. Mr. Zunich, we're here on a hearing on a revocation of your probation. The laws of Colorado set out the procedure that I'm required to follow when that kind of allegation has been made against you. This allegation was first made in an order regarding the complaint of probation was filed on November 25th of 2025. And then there was a summons where you were served with a filing of the complaint of probation. Have you had a chance to review that complaint?
Yes.
Okay. So what we do when we have an allegation that somebody has violated the terms and conditions of their revocation hearing is that the court has to make sure that you first understand what the allegations are, and then I make sure that you know what your rights are and the potential consequences if I determine that you have violated your probation. And then I'm going to ask you how you want to proceed. And there's basically two options. One, you can plead not guilty and we'll have a full-blown hearing, or you can plead guilty and then we can make a determination of whether or not your probation should be revoked or revoked and reinstated. And that's what we're here to do this morning. So let me first make sure that you understand what your rights are when we are dealing with an alleged probation revocation. In a revocation hearing, this is a little bit different than when it's a criminal matter, because in a revocation hearing, the only thing that you would have is a hearing in front of the court, and the court makes a determination by a preponderance of the evidence whether there's sufficient evidence to establish that a violation has occurred. So you have a hearing, but you don't have a trial. But the other rights that you would have available to you, just like in any criminal matter, still exist. You have the right to remain silent. You don't have to say anything, and anything that you do say could be used against you in the court of law. You have the ability to subpoena witnesses, to confront those witnesses and cross-examine them. You have the ability to call your own witnesses to testify on
I was
your
denied
behalf.
that in the original case way back.
So I can't do anything about what transpired in the original case. I can only
The
talk
judge
about,
has since been released for misconduct, and one of the arresting officers is absconded from justice.
You should care because, just like a professional athlete, you are responsible for anything you put into your body when you're required to undergo a drug test. I also want you to remember exactly what he just said, that even he doesn't know whether the substance could cause a false positive result for methamphetamine. That detail will become important later in this video. Now, the prosecutor is about to respond to his objections regarding whether the court has jurisdiction over him.
the only thing that I can do for you here today is address the revocation of probation. That's the only thing that I'm authorized to do at this point in time. And so I'm just going to tell you your rights that are associated with this hearing. So in addition to the cross-examination rights, I've talked about the right to remain silent, the right to a hearing. You have the right to persist, in your not guilty determination. And if I were to make a finding, you would have a right to appeal that particular finding. It's the burden on the prosecution to establish by a preponderance of the evidence that that's been violated. Do you understand your rights in this matter?
I comprehend them.
Yeah, I'm not asking if you agree with them, but whether or not you understand them. And you indicated that you had reviewed a copy of the complaint. Let me just tell you what you have, what is alleged against you. One of the standard conditions of probation is that you will not use alcohol or possess any controlled substances without a prescription or in a manner that is inconsistent with a prescription, or use any illegal, dangerous, or abusable drugs or substances. The use or possession of medical marijuana is permissible unless such use or possession is prohibited by a court order or your conviction is for a violation of the Colorado Marijuana Code. The use or possession of natural medicine or natural medicine product is not permissible. And there's been an allegation that you have violated that by testing positive for methamphetamine and for alcohol. Standard condition number
And for alcohol.
Standard condition number 7 states that you agree to submit to drug and alcohol testing as directed by the probation officer. That you understand that you are responsible for the cost of testing unless other arrangements have been made through the probation officer. And it's my understanding that you missed a number of UAs and a number of phone calls regarding that. As far as treatment goes, there's a standard condition number 8, which requires you to actively participate in, cooperate with, and successfully complete any referral, evaluation, assessment, or recommended program. These programs may include, but are not limited to, placement in a residential or outpatient program, counseling or treatment for drugs or alcohol, mental health, domestic violence, cognitive behavioral, offense-specific, or anger management. And that you agree to sign any necessary releases of information and that you are responsible for the cost of treatment and services unless other arrangements have been made through the probation officer. And as of the date that this complaint was filed, that you had not signed up for any treatment. And then the last condition, number 12, states that you will comply with any requirements of the probation officer, including answering all reasonable questions asked by the probation officer in order to meet the conditions imposed by the court, and that you agree to sign all releases of information necessary for the probation department to communicate with others regarding supervision. And it's my understanding that standard condition number 12 is alleged to be violated for failing to comply with the terms of the electronic home monitoring. Lastly,
I object to that.
so
I've done 90 days on an ankle bracelet
so
already.
so what I'm doing first of all is just letting you know what the allegations are and not whether you agree with them, but just letting you know what the allegations are.
I'm aware of it.
And then the next step I'm going to ask you is whether or not how you would like to proceed. Do you want to admit to any of the allegations
I
or?
refer you back to the notice.
Okay. You don't have to say anything, but if you don't say anything further in this proceeding, then I am going to ask the people to proceed with their evidence to determine whether or not you have violated the conditions of your probation.
I work every day till late hours in the night. For 90 days, I did not do that, which disappointed many customers. I'm adverse to any of their allegations. I complied under duress without my consent, under threat of 4 years of jail for crossing a yellow line in a rainstorm. And I didn't get due process. I was denied any witnesses on my side. I was slandered in court, in open court. I still done the 90 days. I take a supplement called methylene blue. Whether that tests positive for methamphetamines or not, I don't know, and I really don't.
All right. Now that the issue of jurisdiction has been established through both statute and case law, the prosecution is ready to call its first and only witness. I'm going to skip over most of testimony and focus only on the moments when the defendant decides to interrupt or insert his own comments. What's important to understand is that he had accumulated multiple violations, including failing several UA, urinalysis, drug tests, repeatedly failing to appear for required testing, and committing multiple violations related to the terms of his home confinement through his electronic monitoring tether. With that background in mind, let's continue and see what happens next.
Defendant or not.
But that is, and no alcohol have I consumed. That's total out and out bullshit.
Okay. So as I said earlier, we're not here to undo what that original sentence is. And I'm sorry that you are frustrated and disgruntled. With all pleas in this jurisdiction, there's always questions about whether or not you felt like you were forced or coerced or whether or not anybody put any sort of undue pressure on you. There's always a mechanism for challenging that later, but the mechanism is not on a hearing for a probation revocation. You were initially charged with 11 counts. You pled guilty to one of those counts, and your time was originally suspended, and the condition of 60 days of probation was also suspended with the condition that you comply with the 90 days of electronic home monitoring. There's been these allegations that you violated. It sounds like you have disagreement about whether or not you violated, and that's really what the purpose of today's hearing is for the people to present whatever evidence they have about whether or not you violated. For me, and you're entitled to cross-examine them on that particular evidence. You will also be entitled to give your own statement as to anything that you want me to know about whether or not that you have violated. And after that, I will make a determination. When I make that determination, if you have violated, if the people have met their burden of proof, I will also have to make a determination about what the consequence should be. And we're not at that stage because I don't even know if they have enough evidence to meet that burden. So why don't we go forward now? We'll have Mr. Bema will present whatever evidence he has, and you'll have an opportunity to rebut that. Mr. Bema?
Thank you, Your Honor. If I can quickly just address the motion that I just received prior to the hearing. Essentially, the gist of it, as I can understand on a quick read, is that jurisdiction isn't appropriate because the parties aren't proper. Specifically, the objection was to the people of the state of Colorado presenting this case and prosecuting this case, but the Article 6, Section 22 of the Colorado Constitution requires actually that the prosecutions be carried out in the name of the people of the state of Colorado, and that the constitutional provision requires that in all prosecutions for violations of Colorado law, the process shall run in the name of the people of the state of Colorado, and all prosecutions shall be brought in the people's name. And that's People v. Hunter, 666 P2D 570, 1983. Also People v. Sommers, SOMMERS, 200 P3rd 1089, 2008. And so with that, that's just for the court's consideration. In the bigger, ruling on the case as a whole, now prepared to move forward with evidence we call probation officer Wanda Pierce.
With the witness testimony now concluded, the prosecution has finished presenting its evidence. The next stage of the hearing is cross-examination, where the defendant will have the opportunity to question the witness and challenge the testimony that has been presented. As expected, this is where things begin to take an interesting turn.
What is that?
That is the standard conditions of probation.
Okay. And how do you ensure that people are aware of the terms and conditions of probation?
I review each one with them and then they initial as I go through them. And I answer any questions that they may have in regards to each term and condition.
Okay. And did you do that in this case?
Yes.
Did you meet with Mr. Zunich in this case and go through that process that you just described?
Yes.
And is Mr. Zunich here in the courtroom?
Yes.
Can you identify him?
He's in the blue shirt sitting directly in front of me.
Have I ever caused you harm or injury or loss?
Mr. Zunich, that is not the objection. She's just asking to identify
It's got to
you.
be a victim, Marbury versus Madison.
So the prosecution has the ability to ask questions right now. If there is an objection to the particular question that is based on rules of evidence, then you are entitled to make that. But he was simply asking whether or not she could identify you. So the objection is overruled.
And if I could let the record reflect that Ms. Pierce has identified Mr. Zunich.
So noted.
Yes.
Condition 1, what condition is that?
Are you referring to the first condition, number 6?
Correct. Sorry, that's a fair correction. So
Okay.
yes.
Yes, I am familiar with it.
Okay, what is that condition?
No use of drugs or alcohol
How and
unless prescribed.
was that condition complied with?
No.
And
In
What-
your opinion,
You'll have a chance, Mr. Zunich, to question her. So just make note of the questions that you want to ask her afterwards. But we're going to let Mr. Bama go ahead and ask his questions.
Your Honor, the people would move to admit People's Exhibit 3.
Any objection?
no objection. I've got questions.
You'll have a chance to ask her questions about that. It's admitted.
Okay. And so you said that this process is one where you ask the lab to look a little bit deeper into what.
Objection. Does the lab actually look for specific methylene blue
So you'll have,
as a supplement?
Mr. Zurich, you'll have a chance to ask those questions yourself after Mr. Bama is done questioning the probation officer.
So this lab goes a little bit deeper, I think, as you explained it, into what the substances are, right?
Correct.
And what was the conclusion from the lab?
Negative for amphetamine, which would be a prescribed amphetamine, and positive for methamphetamine.
And what does that mean to you?
Street meth.
And there are,
Objection. What's the difference between street meth,
I'm not a
methylene blue?
lab tech.
Mr. Zunick, you will have a chance to ask her these questions when it's your turn. So let Mr. Bama continue to ask her the questions, and then you can ask her the questions that you have concerning what the lab report says or doesn't say.
Your Honor, people would move to admit Exhibit 4.
Any objection?
Yeah, I object. What's abnormal?
Okay, it's just on an evidentiary basis. So you'll have a chance to ask that question. That People's Exhibit number 4 is admitted.